Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only. The information provided here does not constitute legal, financial, or professional advice, and no attorney-client relationship is formed by watching this content. Divorce laws, court procedures, and judicial interpretations vary significantly by state, county, and even individual presiding judges. The legal landscape is subject to change, and the historical trends discussed may not reflect future outcomes in your specific jurisdiction. You should not act or refrain from acting based on any information provided in this video without seeking professional legal counsel in your specific state. Always conduct your own due diligence and consult with a qualified attorney licensed to practice in your area before making any decisions regarding your domestic relations or financial future. The American Midwest is often romanticized as the land of stable families, white picket fences, and the bedrock of traditional values. But beneath that serene surface lies a legal machine that processes thousands of men every single year, often leaving them financially depleted, emotionally isolated, and legally blindsided. If you are a man living in the Midwest, whether you are in the skyscrapers of Chicago, the suburbs of Indianapolis, or the rural stretches of Iowa, and you find yourself facing the end of your marriage, you are about to enter what many call the heartland gauntlet. Historical trends indicate that while divorce rates nationwide have seen fluctuations, the financial and custodial stakes for men in the Midwest remain uniquely challenging, due to a blend of traditional judicial mindsets and modern no-fault statutes. You might think that because you have been a provider, a protector, and a hard worker, the system will naturally recognize your contribution. However, the reality is that without a deep understanding of the specific regional mechanics of Midwestern law, you could lose decades of wealth and, more importantly, your relationship with your children in a matter of months. This is the beginning of a 10-part masterclass designed to strip away the myths and provide you with a comprehensive deep dive into the reality of divorce for men in this specific region. Today we solve the problem of the unknown. We are going to deconstruct the initial filing phase, the specific state nuances between equitable distribution and community property, and the immediate legal traps that catch men off guard in the first 48 hours of a filing. To understand the stakes, we have to look at the concept of the no-fault divorce system as it is applied in the Midwest. While every state in the region, from Ohio to Minnesota, now operates under some form of no-fault legislation, the way this plays out in a local courtroom can be jarring. In a no-fault system, the court does not care about infidelity, abandonment, or the moral failings that led to the breakdown of the marriage when it comes to the legal right to end the union. For many men, this feels like a betrayal of the justice system. You may have spent 20 years building a career and maintaining a home, only to find that the court views the dissolution of that partnership as a simple administrative contract termination. However, historical trends show that while fault is removed from the ability to get a divorce, it often sneaks back into the room during the division of assets or the determination of maintenance, which is the Midwest term for alimony. Take, for example, the state of Illinois. In 2016, Illinois underwent a massive overhaul of its Marriage and Dissolution of Marriage Act. They moved toward a standardized formula for maintenance, which was designed to create predictability. For a man earning a high income, this formula can be a mathematical hammer. The potential outcome under current guidelines often involves a calculation where the payer's obligation is roughly 33% of their net income minus 25% of the receiver's net income. When you add child support on top of that, many men in the Midwest find themselves living on less than 40% of their original take-home pay, while still being expected to maintain a residence suitable for parenting time. This is not just a financial shift. It is a total lifestyle restructuring that happens almost overnight. Moving east to Ohio, the legal landscape shifts again. Ohio is an equitable distribution state, not a community property state. This is a critical distinction that many men misunderstand. Equitable does not mean equal. It means what the judge deems fair. While the starting point is often a 50-50 split of marital assets, the court has broad discretion to deviate based on a long list of statutory factors. Historical trends in Ohio courts show that judges may look at the future earning capacity of both parties. If you have spent years climbing the corporate ladder in Columbus or Cincinnati while your spouse stayed home, the court may view your earning potential as a massive asset in itself, potentially leading to an unequal distribution of tangible assets like the marital home or retirement accounts to offset your future income. Then there is Wisconsin, the regional outlier. Wisconsin is one of the few community property states in the Midwest. This means that, generally, any asset acquired during the marriage is owned 50-50 by both spouses, regardless of whose name is on the title or who earned the money to buy it. For a man who has meticulously managed his own business or a separate investment portfolio, the Wisconsin system can be a shock. Case studies have shown that even premarital assets can sometimes be transmuted into marital property if they are commingled, such as using a premarital inheritance to pay down a joint mortgage on a home in Madison or Milwaukee. The first 48 hours after a divorce is filed are perhaps the most dangerous for any man in the Midwest. This is when the standing orders or automatic temporary restraining orders, known as ATROs, typically go into effect. In many Midwestern jurisdictions, the moment a petition is filed and served, a legal freeze is placed on the marital estate. This means you are historically prohibited from moving large sums of money, changing beneficiaries on your life insurance, or even canceling the family's cellular plan or Netflix account. Men who react emotionally and try to secure their assets by moving funds to a separate account often find themselves facing a judge for contempt of court before the divorce has even truly begun. The court views this as a violation of the status quo. The status quo is a powerful legal concept in the Midwest. Judges generally want to keep everything exactly as it was on the day of the filing, until a final decree is reached. If you were paying all the bills and providing a certain standard of living, the court will likely order you to continue doing so through a temporary order. This creates a financial pincer movement. You are paying for your own new living expenses, your legal fees, and the full expenses of the household you no longer live in. This is why depth of preparation is vital. You cannot afford to be reactive. In rural Midwestern counties, the dynamic changes even further. The legal community in a smaller county in Nebraska or Kansas is often very tight-knit. The historical trend in these areas sometimes leans toward more traditional views of gender roles compared to major metropolitan centers like Chicago or Minneapolis. A man in a rural jurisdiction might face a bench that still holds a subconscious bias toward the mother as the primary caregiver, despite modern statutes that favor frequent and continuing contact for both parents. Understanding the local culture of the specific county courthouse is just as important as understanding the state statutes. Furthermore, we must look at the psychological landscape. Men in the Midwest often carry a deep-seated identity as the provider. When a divorce filing threatens that identity, the natural impulse is to fight or to retreat. Both are tactical errors. A deep-dive approach requires you to view the divorce not as a personal failure or a moral battle, but as a high-stakes corporate dissolution. You are not just losing a partner, you are reorganizing a 20-year financial entity. Historical data suggests that men who approach the process with clinical, data-driven detachment fare significantly better in the final potential outcomes than those who lead with emotion. In this masterclass, we will eventually cover the complexities of the silver tsunami, the rising trend of late-life divorces in states like Michigan and Iowa, where men who are nearing retirement find their 401ks and pensions on the chopping block just as they are preparing to exit the workforce. We will also dissect the specific nuances of the Indiana presumption of equal division, which is one of the strongest in the country, and how men can prepare for the high bar required to rebut that presumption. By the end of this 10-part series, you will have a comprehensive understanding of the Midwestern legal engine. You will know how to identify separate versus marital property, how to navigate the pitfalls of temporary hearings, and how to protect your long-term financial viability. The goal today was to set the stage. The Midwest is not a monolith, but its courts share a common thread of valuing the status quo and utilizing formulas that can be punishing to the unprepared. You now have the baseline. You understand that no fault does not mean no consequence, and you know that the first 48 hours can set the tone for the next 2 years. We are just getting started on the mechanics of protecting what you have built in the heartland. To understand the financial battlefield of 2026, we have to look at the single most contentious element of any Midwestern divorce, the classification of assets. In the legal world, there is a wall between what you brought into the marriage and what was built during it. This is the difference between separate property and marital property. While the theory sounds simple, the application in states like Michigan, Minnesota, or Missouri is where most men lose their footing. Historical trends show that the most common mistake made by men is the failure to account for transmutation. This is a legal process where an asset that was once entirely yours becomes property of the marriage, and therefore, subject to a 50-50 or equitable split. Imagine a man named David in 2026. David lives in a suburb of Des Moines, Iowa. Before he got married 15 years ago, he owned a home outright that he inherited from his grandfather. At the time of the wedding, the house was worth $250,000. Throughout the marriage, David and his wife lived in that home. They used joint income to pay for a new roof, a kitchen remodel, and the property taxes. In the eyes of an Iowa judge in 2026, that one separate inheritance has likely been commingled. Because marital funds were used to maintain and improve the asset, the court may rule that the appreciation in value, or even the entire property itself, has transmuted into a marital asset. David enters the divorce thinking he has a $600,000 shield, only to find out that the shield has melted into the common pot. This is why the first step in any deep dive into Midwestern divorce is a forensic look at your history. You must be able to trace every dollar. If you cannot prove with a paper trail that an asset remains separate and was never touched by marital funds, the court's default position is almost always that it belongs to both of you. In the 2026 economic climate, the marital home has become an anchor, with interest rates having stabilized but remaining higher than the record lows of the early 2020s. Many Midwestern men find themselves in a trap. Historically, the standard move was to sell the house and split the equity. But if you have a 3% mortgage on a home in Overland Park, Kansas, or Naperville, Illinois, letting go of that loan is a massive financial blow. If you stay, you have to buy out your spouse's equity, which usually means refinancing at 2026 rates, potentially doubling your monthly carrying costs. If you leave, you are entering a rental market that has seen significant inflation over the last 5 years. Case studies from 2025 and early 2026 show an increasing trend of birdnesting in the Midwest, where the parents rotate in and out of the family home to maintain the children's stability and avoid the immediate necessity of selling a low-interest asset. However, this requires a level of cooperation that is often absent in high-conflict cases. The next layer of the Heartland gauntlet is the retirement account. Whether it is a 401k from a manufacturing firm in Detroit or a pension from a state job in Madison, these are often the largest assets outside of the home. In the Midwest, these are almost universally considered marital property to the extent they were earned during the marriage. To divide them, you use a legal instrument called a Qualified Domestic Relations Order, or QDRO. This is a highly technical document that tells the plan administrator how to split the account without triggering immediate taxes or early withdrawal penalties. Many men make the mistake of assuming the divorce decree itself is enough. It is not. Without a finalized and filed QDRO, you could be on the hook for your ex-spouse's share of the taxes, or worse, you could find yourself unable to retire because the math was not handled correctly at the time of dissolution. Let's look at a case study of Mark from Indianapolis. Mark is 54 years old and has worked for the same logistics company for 22 years. His 401k is valued at $800,000. He married his wife 10 years into his career. Mark assumes that since he worked for 10 years before the marriage, at least half of that money is safe. But the Midwest courts use specific formulas to determine the marital portion. They look at the value on the date of the marriage versus the value on the date of the filing, but they also account for the growth of the premarital portion. If Mark cannot produce the specific statements from 12 years ago showing the exact balance on his wedding day, the court may simply divide the whole $800,000. In 2026, the burden of proof is on the party claiming an asset is separate. The court does not do the detective work for you. This brings us to the most grueling phase of the Midwestern divorce process: discovery and the financial affidavit. Every state in the region, from the Dakotas down to Kansas, requires a full sworn disclosure of every single penny you own. This is not a suggestion, it is a court mandate. In 2026, this disclosure has become incredibly complex due to the rise of digital assets and diverse income streams. If you have a Robinhood account, a crypto wallet, or a side hustle on a digital platform, it must be listed. Historical trends show that judges in the Midwest have zero tolerance for what they perceive as financial hiding. If a judge finds that you intentionally omitted a high-value asset, they have the power to award a higher percentage of the remaining estate to your spouse as a sanction. They can also order you to pay your spouse's legal fees, which in a contested case, can easily reach 5 figures. The financial affidavit is the document that will dictate your life for the next decade. It lists your gross income, your net income, and every recurring expense from your mortgage down to your monthly car wash subscription. In the Midwest, where the cost of living varies wildly between a city like Chicago and a town like Kearney, Nebraska, these numbers are scrutinized. The court will compare your stated expenses against your historical bank statements. If you claim you need $5,000 a month to live, but your bank statements show you have been spending $8,000, the court will use the higher number to determine your standard of living. which directly impacts the amount of maintenance or child support you may be ordered to pay. For the business owners in our audience, the farmers in Iowa, the shop owners in Ohio, the tech consultants in Minneapolis, the stakes are even higher. In 2026, business valuations have become a primary theater of war. The court will likely appoint a forensic accountant to determine the fair market value of your business. This is not just what the equipment is worth. It is a calculation of your future earnings, your brand, and your goodwill. Historically, men in the Midwest who own businesses are often forced to take on debt to buy out their spouse's interest in the company just to keep the doors open. Imagine if you own a construction firm in Omaha. The court values the business at $1.5 million. Your spouse is entitled to half of that marital value. You may not have $750,000 in cash. You might be forced to give up your entire share of the home equity and your retirement accounts just to keep your business. This is why understanding the valuation methods used in your specific state is critical before the first filing ever happens. We have covered the assets, the transmutation traps, and the heavy weight of the financial affidavit. But assets are only half of the story. The true heart of the Midwest divorce for any man is the battle for his time and his influence. In the next part of this masterclass, we move from the ledger to the living room. We are going to dive into the best interests of the child standard as it is applied across the heartland in 2026. We will discuss the rise of the 50-50 custody presumption and why, despite the law, many men are still being relegated to every other weekend fathers. You need to know the specific behaviors that Midwestern judges look for when deciding who gets the final say in education, healthcare, and religion. If you think the financial fight was tough, wait until you see how the system evaluates your worth as a parent. We will break down the guardian ad litem process and the psychological evaluations that can make or break your case. The custody battle is where the true character of the Midwest court system reveals itself, and you cannot afford to go in without a map. The moment you enter a Midwestern courtroom to discuss your children, you are no longer just a father. You are a litigant navigating a subjective psychological landscape known as the best interests of the child. In 2026, this standard remains the universal North Star for judges from the Great Lakes to the Great Plains, but its application is anything but uniform. While the terminology has shifted in states like Illinois, which now refers to custody as the allocation of parental responsibilities, the underlying tension for men remains the same. You are fighting against a historical inertia that often defaults to the mother as the primary emotional anchor. To win your seat at the table, you must understand that the court is not looking for the better parent. It is looking for the parent who best facilitates the child's relationship with the other parent. This is a subtle but lethal distinction that many men miss. Let's look at a case study of Robert in 2026. Robert is a project manager in Overland Park, Kansas. He has spent a decade being the primary breadwinner, often working 50 hours a week to provide a high standard of living. When the divorce filing hit, Robert assumed his role as a provider would translate into a position of strength in a custody negotiation. However, the Kansas courts, like many in the Midwest, look at the historical division of labor within the home. If Robert's wife was the one who consistently took the children to their pediatric appointments at the University of Kansas Health System, or managed the school calendar in the Blue Valley School District, the court views her as the primary caretaker. In the 2026 legal environment, being a provider is often seen as a secondary contribution to the day-to-day logistical management of a child's life. Robert's challenge is to prove that his work schedule is flexible enough to accommodate the transition to a true 50-50 parenting split. This leads us to the rise of the 50-50 presumption. States like Missouri and Kentucky have been pioneers in the region by passing legislation that creates a rebuttable presumption that equal parenting time is in the best interest of the child. This is a massive shift from the historical trends of the 1990s and early 2000s. However, a rebuttable presumption is not a certainty. It simply means the court starts at 50-50, but the other side can pull the lever back by presenting evidence of your unavailability, your lack of involvement in school activities, or your living situation. Imagine if you move into a one-bedroom apartment in downtown St. Louis, while your spouse remains in the four-bedroom family home in the suburbs. Even with a 50-50 presumption, a judge may rule that having the children commute 40 minutes each way during the school week is not in their best interest, effectively reducing your time to weekends. The logistics of your post-divorce life in 2026 must be engineered to support the custody outcome you desire before you ever step foot in mediation. The most influential person in your custody case will likely not be the judge, but an individual known as the guardian ad litem, or GAL. In the Midwest, the GAL is an attorney appointed by the court to represent the interests of the children. They are the eyes and ears of the bench. Historical trends in 2026 show that judges follow GAL recommendations in over 80% of contested cases. This individual will interview you, your spouse, your children, and potentially your neighbors and teachers. For a man in the Midwest, the GAL interview is a high-stakes performance. You must avoid the common trap of using this time to vent about your spouse's failings. If you spend your 2-hour interview with the GAL explaining why your ex-wife is a terrible person, the GAL will likely report that you are unable to co-parent and are contributing to a high-conflict environment. The strategic move is to focus entirely on your bond with the children and your detailed plan for their future. Consider the case of Michael in Grand Rapids, Michigan. Michael was facing a high-conflict divorce where his spouse made allegations of emotional instability. The court appointed a GAL. Michael, instead of fighting the allegations with anger, provided the GAL with a binder that included the children's immunization records, a color-coded calendar of their extracurricular activities, and a list of 3 local therapists he had already researched to help the kids through the transition. By demonstrating that he was the more organized, child-centric parent, Michael flipped the narrative. The GAL's final report stated that Michael's home provided the superior structural environment for the children. This is the level of depth required in 2026. You are not just a dad. You are a lead administrator for your children's lives. We must also discuss the psychological evaluation, often referred to in some jurisdictions as a 730 evaluation. These are becoming more common in 2026 Midwestern divorces when allegations of parental alienation or fitness are raised. These evaluations are conducted by forensic psychologists and can cost anywhere from $5,000 to $15,000. They involve standardized testing such as the MMPI-3 and multiple observation sessions. Historical data suggests that men often struggle with these evaluations because they tend to underreport stress, which psychologists can interpret as defensiveness or a lack of insight. You have to be prepared for the clinical nature of this process. It is a grueling, invasive experience where your entire history, including any past struggles with mental health or substance use, will be scrutinized under a microscope. In the Midwest, there is also the specific issue of the right of first refusal. This is a common clause in 2026 parenting plans in states like Indiana and Ohio. It states that if one parent is unavailable to watch the children for a specific period, usually 4 to 8 hours, they must call the other parent and offer them the time before calling a babysitter or a grandparent. While this sounds fair, it is often used as a weapon in high-conflict cases. If you are a man with a demanding career in Chicago or Indianapolis, your spouse may use the right of first refusal to effectively claw back your parenting time every time you have a late meeting or a business trip. Understanding how to cap these hours or define what constitutes unavailability is a critical step in protecting your time. Then there is the threat of relocation. In the 2026 economy, people move for work more than ever. But in the Midwest, many states have strict move-away laws. If your spouse decides they want to move the children from Minneapolis to Florida to be closer to family or a new job, the burden of proof in many jurisdictions is on the parent moving to show that the move is in the child's best interest. However, historical trends show that if the mother has been the primary caretaker, courts are often more permissive of these moves, provided a long-distance parenting plan can be established. For the father left behind, this is a devastating outcome. You must be prepared to file an immediate injunction the moment a move is mentioned, as once the children are settled in a new state, it becomes exponentially harder to bring them back. We have explored the psychological and logistical warfare of the custody battle, from the GAL to the 50-50 presumption. But as any man in the Midwest knows, the children's needs are inextricably linked to the financial demands of the state. Even if you secure 50-50 custody, you may still find yourself writing a massive check every month. In the next part of this masterclass, we are going to dive into the cold, hard math of child support and maintenance. We will deconstruct the income shares model used in states like Illinois and the percentage of income model used in Wisconsin. We are going to talk about what happens when the court imputes income to you, meaning they decide you should be earning more than you are, and how to defend against a maintenance award that could last for the rest of your working life. The fight for your time is over. Now the fight for your future income begins. In the 2026 economic landscape, your future income is often the most significant on the table, and the Midwest uses 2 distinct mathematical engines to decide how much of it you keep. To navigate this, you must first understand the income shares model versus the percentage of income model. Most Midwestern states, including Illinois, Ohio, Michigan, and Iowa, have adopted the income shares model. This model is based on the idea that the child should receive the same proportion of parental income that they would have received if the parents lived together. The court looks at the combined net income of both parents and then references a state-specific table to find the basic support obligation. Imagine if you are James, a software engineer in Columbus, Ohio in 2026. You earn $120,000 a year, and your spouse earns $40,000. Your combined income is $160,000. The state of Ohio has a schedule that says for 2 children, a couple earning $160,000 should spend, for example, $2,500 a month on their kids. Because James provides 75% of the total income, his basic obligation is 75% of that $2,500. However, the calculation does not stop there. In 2026, the Midwest has become hyper-focused on the number of overnights. If James has the children for more than 90 overnights a year, he may receive a parenting time credit. If he reaches 147 overnights, the threshold for shared physical custody in many jurisdictions, the formula shifts dramatically. In this scenario, the court acknowledges that James is already providing food, housing, and utilities for the children during his time, and his monthly check to his ex-spouse is adjusted downward. Potential outcomes vary, but a man who moves from 80 overnights to 150 overnights can see his monthly obligation drop by hundreds of dollars. Now, contrast this with the percentage of income model used in Wisconsin. Historically, Wisconsin has used a flat percentage: 17% of gross income for 1 child, 25% for 2, and 29% for 3. For a high-earning man in Milwaukee or Madison, this is often a much more aggressive calculation because it does not care what the other parent earns. If you earn $200,000, you pay the percentage based on that $200,000, even if your ex-spouse is also a high earner. This is why location within the Midwest is your primary financial variable. A man moving across the border from Kenosha, Wisconsin, to Waukegan, Illinois, faces an entirely different financial reality despite being only 15 miles apart. Beyond the basic monthly check, you have the hidden multipliers, extraordinary expenses. In 2026, the costs of youth sports, private education, and healthcare have outpaced general inflation. Midwestern judges typically order these expenses to be split pro rata. If you are responsible for 70% of the income, you are likely responsible for 70% of the travel, hockey fees, the orthodontics, and the summer camps. Historical trends show that men often overlook these costs during negotiations, only to find that their actual monthly outlay is 30% higher than the base child support amount. You must insist on language that requires mutual agreement before these expenses are incurred, or you could find yourself billed for a private school tuition you never approved. Then comes the most feared topic in the heartland: maintenance, formerly known as alimony. In 2026, many Midwestern states have moved toward a formulaic approach to remove judicial whim, but the math remains punishing. In Illinois, for example, the formula is generally 33% of the payer's net income minus 25% of the payee's net income. The kicker is the duration. The Midwest uses a sliding scale based on the length of the marriage. If you were married for 5 years, you might pay maintenance for 1 year. But if you hit the 20-year mark, the potential outcome is often indefinite maintenance. In the eyes of a 2026 court, a 20-year marriage is a permanent financial partnership. Case studies from 2025 and 2026 show a rising trend of the lifestyle maintenance trap. Imagine if Brian, an executive in Des Moines, Iowa, has been married for 18 years. His wife stayed home to raise the children. The court will look at the standard of living established during the marriage. If Brian and his wife lived in a 4,000 square foot home and took 2 international vacations a year, the court may determine that his wife is entitled to maintenance that allows her to approximate that lifestyle, regardless of her own ability to work. This is where the concept of the vocational expert becomes your greatest tool or your worst enemy. If your spouse claims they cannot work or are underemployed, the court can conduct a vocational evaluation. A specialist will analyze their skills, education, and the 2026 job market in cities like St. Louis or Indianapolis to determine what they could earn if they tried. This is known as imputing income. If the expert finds your spouse could earn $50,000 as an administrative manager, the judge can calculate maintenance as if they were already making that money. This prevents a spouse from intentionally remaining unemployed to maximize their award. However, The imputation of income is a double-edged sword. If you, the man, decide to change careers or take a lower-paying job to reduce your stress during the divorce, the court will likely impute your previous higher income to you. Historical trends in Midwest courts show that judges have very little sympathy for a man whose income suddenly drops the moment a divorce is filed. They call this voluntary underemployment. Unless you can prove a medical necessity or a legitimate layoff with a documented job search, the court will hold you to your highest earning capacity. Step by step, you must document every job application and every rejection if your income has decreased, or you will be paying support based on a salary you no longer receive. There is also the 2026 reality of the tax treatment of these payments. Since the tax law changes of the late 2010s, maintenance is no longer tax deductible for the payer and is not considered taxable income for the receiver. This means if you are ordered to pay $3,000 a month in maintenance, that is $3,000 of after-tax money. For a man in a high tax bracket in a state like Minnesota, which has a significant state income tax, you effectively have to earn nearly $5,000 just to pay that $3,000 obligation. This realization often leads to a phenomenon known as the divorce cliff, where a man's standard of living drops by 50% or more while his ex-spouse remains stable or increases due to the tax-free nature of the support. We have deconstructed the math of support, the formulas for maintenance, and the dangers of imputed income. You now see that the financial decree is not just a piece of paper. It is a long-term lien on your labor. But even if you manage the math, there is one area where the court's power is most absolute and most invasive. In the next part of this masterclass, we are moving into the dark territory of domestic injunctions and orders of protection. We will discuss how a single allegation in a Midwestern courtroom can result in you being forcibly removed from your home and barred from seeing your children without a single piece of physical evidence. We will look at the tactical use of these orders in 2026, and the specific steps you must take to defend your reputation and your access to your house. The financial fight is a marathon, but the fight for your basic rights can be lost in a single afternoon. In the legal trenches of the 2026 Midwest, the most immediate and devastating weapon available in a domestic dispute is the ex parte order of protection. To understand why this is called the silver bullet in matrimonial law, you have to understand the mechanism of the emergency hearing. In states like Illinois, under the Illinois Domestic Violence Act, or in Michigan with personal protection orders, a spouse can petition the court for an emergency order without you even knowing the hearing is taking place. This is what ex parte means, one party only. The court's primary directive in 2026 is the preservation of safety, which historically leads judges to err on the side of caution. If a spouse provides a sworn affidavit alleging a fear of physical harm, harassment, or even coercive control, the judge will likely sign the order immediately. You do not get a phone call, you do not get to explain your side, and you do not get to present evidence. You simply receive a knock on the door from a sheriff's deputy. Imagine if you are Christopher, a middle manager living in a quiet neighborhood in Naperville, Illinois, in April 2026. You are in the middle of a tense but otherwise non-violent disagreement about the division of assets. One Tuesday evening, while you are eating dinner with your children, the police arrive. They serve you with an emergency order of protection that grants your spouse exclusive possession of the marital residence. You are given 15 minutes to gather your essentials, clothes, a toothbrush, and perhaps your laptop, before you are escorted off the property. For the next 14 to 21 days, until the plenary hearing occurs, you are legally barred from entering your own home, contacting your spouse, or in many cases, seeing your children. This is the reality of the 2026 legal system. You can be rendered homeless and childless in less than half an hour based on a single-sided narrative. The definition of abuse has expanded significantly in Midwestern statutes over the last decade. Historically, an order of protection required evidence of physical battery or a direct threat of violence. In 2026, the net is much wider. Many jurisdictions now recognize emotional abuse, financial exploitation, and digital harassment as valid grounds for an order. If you have sent 20 consecutive text messages in a heated argument, or if you have restricted access to a joint bank account as a way to control the situation, these actions can be framed as domestic transitions into the realm of legal abuse. Case studies from 2025 show that men who engage in high-conflict digital communication are the most vulnerable to these orders. The court views a barrage of angry emails or texts not just as venting, but as a pattern of harassment designed to cause emotional distress. The consequences of a served order of protection extend far beyond your living situation. In 2026, the professional impact for men in the Midwest is catastrophic. If you work in a field that requires a security clearance, a professional license, or the ability to carry a firearm, an entry of a protection order into the law enforcement agency's data system, or the National Crime Information Center, can trigger an immediate suspension of your credentials. Consider a man in Indianapolis who works as a commercial pilot or a nurse in a major hospital system. The moment that order is entered into the system, their employer may be notified, or the background check required for their next contract will return a red flag. Historical trends indicate that even if the order is eventually dismissed at the plenary hearing, the initial filing can cause permanent reputational damage within your professional network. Then there is the firearm trap. Under federal law, specifically the Lautenberg Amendment, and reinforced by various 2026 Midwestern state statutes, an individual subject to a qualifying order of protection is prohibited from possessing firearms or ammunition. In states like Wisconsin or Missouri, where hunting and firearm ownership are deeply ingrained in the local culture, this is often the most shocking realization for men. You may be ordered to surrender your entire collection to the local police department or a third party within 24 hours. Failure to comply is a felony. Potential outcomes for men who attempt to hide a single hunting rifle or a box of shells are severe, often leading to criminal charges that permanently overshadow the civil divorce proceedings. To defend against these orders in 2026, you must prepare for the plenary hearing with clinical precision. This is your first opportunity to present your side of the story, but the burden of proof is often lower than in a criminal trial. It is typically a preponderance of the evidence standard, meaning the judge only needs to believe it is more likely than not that the allegations have merit. Step by step, your defense must focus on disproving the specific incidents cited in the affidavit. In 2026, your greatest allies are digital footprints. If your spouse alleges you were at the house threatening them at a specific time, but your Google Maps timeline, your Uber receipts, or your office keycard logs show you were 10 miles away, you have an objective shield. Case studies have shown that the most effective way to overturn a tactical order of protection is to highlight inconsistencies through discovery. In 2026, this means requesting the other party's social media archives, text message logs, and even smart home data. If a spouse claims to be in fear for their life but is caught on a Ring camera laughing with a neighbor 5 minutes after you left, or if their social media posts show them celebrating the fact that they got the house to themselves, the credibility of the underlying affidavit begins to crumble. However, this process takes time and significant legal expense. You are fighting a war on two fronts: the immediate need to see your children and the long-term need to clear your name. The strategic misuse of these orders in 2026 is often aimed at establishing a new status quo for custody. If you are barred from the home for 3 weeks, and your spouse is the sole provider for the during that time, they arrive at the temporary custody hearing with a narrative of stability. They are in the home, the children are in their routine, and you are the outsider living in a hotel or on a friend's couch. The court, prioritizing the children's lack of disruption, may be inclined to leave that arrangement in place for the duration of the divorce. This is why you must never violate the order, no matter how much you want to explain yourself or see your kids. A single violation, even a neutral text message about a utility bill, can result in your arrest and essentially seal the deal for the other side's custody claims. The Midwest legal system in 2026 is designed to move quickly in emergencies, and while this protects many legitimate victims, it creates a high-stakes environment for men who find themselves on the receiving end of a false or exaggerated allegation. You must treat an order of protection with more gravity than the divorce petition itself. It is a criminal-adjacent proceeding that can strip you of your rights, your property, and your professional future in a single afternoon. You have to be ready to pivot from a civil negotiation to a high-stakes evidentiary defense at a moment's notice. As we move forward, you now understand that the physical world, your home and your presence, can be taken away by a signature. But in 2026, the battle isn't just fought in the physical realm. There is an entire world of hidden data that can either save you or sink you. In the next part of this masterclass, we are diving deep into the digital forensic phase of Midwestern divorce. We are going to talk about the data your car is collecting, the hidden metadata in your photos, and how your smartwatch can be used to testify against you in court. The digital trail you leave every day is being archived, and in a contested divorce, it is the most honest witness in the room. You need to know how to audit your digital life before the opposition does. In the 2026 legal arena, the most dangerous witness against you is not your spouse. It is the device in your pocket. As we move into this deep dive on digital forensics, you must understand that the modern Midwest divorce is no longer just about spoken testimony. It is about the petabytes of data you generate every single day. In 2026, the concept of e-discovery has reached a level of sophistication where nearly every digital footprint can be subpoenaed, analyzed, and used to reconstruct your life with terrifying accuracy. Historical trends show that men often fall into the trap of thinking that because a message was deleted or a post was private, it is gone. In reality, in a contested Midwestern divorce, nothing is ever truly deleted. It is just waiting to be recovered by a forensic expert. Consider the case of Brandon, a marketing executive in Chicago in 2026. Brandon was involved in a high-stakes custody battle. He claimed to the court that he was a dedicated, present father who spent every evening focused on his children. However, his spouse's legal team subpoenaed his smart home data and his fitness tracker logs. The data revealed that while Brandon was physically in the house, his smartwatch recorded his heart rate and movement patterns consistent with high-intensity exercise in the basement for 2 hours every evening, while his phone records showed he was simultaneously active on a sports betting app. The court viewed this as a direct contradiction to his testimony about being engaged with his children. This is the 2026 reality. Your devices do not lie, even when you think they are silent. In states like Minnesota and Ohio, the rules of civil procedure regarding electronically stored information, or ESI, are extremely broad. This includes not just your emails and texts, but also the metadata attached to them. Metadata is the data about your data. Imagine if you send a photo of yourself at a park with your kids to prove you were exercising your parenting time. A forensic audit of that file can reveal the exact GPS coordinates where the photo was taken and the precise millisecond it was captured. If that metadata shows the photo was actually taken 3 weeks prior, or at a different location than you claimed, your credibility with a Midwestern judge will vanish instantly. Historical trends in 2026 indicate that judges are increasingly tech-savvy and have little patience for digital deception. The connected car has become another major front in Midwestern digital warfare. By 2026, most vehicles on the roads in Michigan and Illinois are essentially rolling data centers. Your car's telematics system records where you go, how long you stay there, and even who you might have been with if their phones sync to your infotainment system. Case studies from 2025 show instances where a man's travel logs from his Tesla or Ford F-150 were used to prove he was visiting a specific address that contradicted his claims in a maintenance hearing regarding his living expenses. If you are claiming high fuel and travel costs but your car's internal GPS shows you rarely leave a 5-mile radius, that data can be used to rebut your financial affidavit. One of the most common and devastating mistakes men make in the Midwest is the shared account oversight. Many families in 2026 still operate on shared Apple IDs, Google accounts, or Amazon Prime memberships. If you are still logged into a shared iCloud account, your spouse may have real-time access to your iMessages, your photo stream, and your search history on an iPad or a MacBook left at the marital residence. Potential outcomes for men who fail to secure their digital perimeter include the loss of attorney-client privilege if you are communicating with your lawyer on a device or account that your spouse can still access. You must conduct a digital audit, change every password, enable two-factor authentication on a device only you control, and log out of all shared ecosystems immediately upon filing. We also have to address the legal minefield of recording conversations. This is where the Midwest is sharply divided. If you are in Ohio, Michigan, or Indiana in 2026, these are generally one-party consent states. This means you can legally record a conversation you are a part of without the other person's knowledge. However, if you are across the border in Illinois, it is a two-party consent state. Recording a conversation without the explicit permission of everyone involved can not only lead to that evidence being thrown out of court, but it can also result in felony eavesdropping charges. Historical trends show that men often try to catch their spouse in a lie by recording a phone call or a face-to-face argument. But depending on which side of the state line you are on, this tactical move could end your case and start a criminal one. Then there is the issue of spoliation of evidence. This is the legal term for destroying, hiding, or altering evidence. In 2026, if you realize there is damaging information on your hard drive or your social media, your first instinct might be to delete it. This is a catastrophic error. Midwestern courts have the power to issue severe sanctions for spoliation. If a judge determines you deleted data to keep it away from the other side, they can apply what is known as an adverse inference. This means the judge will legally assume that whatever you deleted was so damaging that it proves the other side's point. They can also order you to pay for the expensive forensic experts required to attempt to recover the data. Step by step, the only safe way to handle your digital history is to preserve it exactly as it is and work with your counsel to determine what is discoverable and what is privileged. Even your 2026 smart home ecosystem, the Ring cameras, the Nest thermostats, and the Alexa speakers can be utilized. Alexa and Google Home devices are constantly buffering audio. While they only supposedly record after a wake word, historical trends in litigation show that these recordings can sometimes be retrieved via a specific court order. More commonly, the logs of when doors were opened, when the security system was armed, and when the lights were turned on or off are used to create a timeline of household activity. If you claim your spouse was never home to care for the kids, but the smart lock logs show her phone entering the house every day at 3 p.m., your argument is undermined by your own home's data. The digital forensic phase is about more than just finding a smoking gun. It is about the totality of your digital lifestyle. In 2026, your banking apps and digital wallets like Venmo or PayPal provide a granular look at your habits. A Midwestern forensic accountant will look for patterns. They will look at your Zelle history for any unrecognized names or recurring amounts that might suggest hidden assets or a secret relationship. They will look at your Amazon order history to see if you are buying items for a new residence that you haven't disclosed. This level of scrutiny is standard in high-asset divorces in cities like Minneapolis or St. Louis. You must view your digital life as a public record starting the moment a divorce becomes a possibility. In the Midwest, where the judiciary often values a man's integrity and transparency, being caught in a digital lie is often more damaging than the actual information you were trying to hide. The goal is to be the most transparent person in the room, so that the data supports your narrative, rather than dismantling it. We have now covered the financial, the custodial, the protective, and the digital battlegrounds. You have seen how the 2026 Midwest legal system can use your own life against you. But after the discovery is finished and the forensics are in, there is one final hurdle that determines how the rest of your life will look. In the next part of this masterclass, we are moving into the high-pressure world of Midwestern mediation and the pretrial conference. We are going to talk about the psychological tactics used by mediators to force a settlement and why 80% of men settle for less than they should because they succumb to decision fatigue. You will learn the difference between a mediator who wants a fair deal and a mediator who just wants a closed file. The endgame is approaching, and you need to know how to hold the line when the pressure is at its peak. In the 2026 legal landscape of the American Midwest, mediation is no longer a suggestion, it is a gatekeeper. Whether you are in the 19th Judicial Circuit of Lake County, Illinois, or facing a domestic relations court in Franklin County, Ohio, the system is designed to keep you out of a courtroom. Judges in the heartland are overwhelmed by the 2026 case backlog, and their primary objective is to force a settlement through alternative dispute resolution. This is where most men lose the war, not because of a bad judge, but because they do not understand the psychological theater of the mediation room. You must realize that a mediator is not there to find the truth, and they are not there to ensure justice. Their sole metric of success is a signed agreement. If they can get you to sign away 10% more of your retirement or an extra weekend of parenting time just to close the file, they will consider it a job well done. Imagine if you are Andrew, a mechanical engineer in Minneapolis, Minnesota, in July 2026. Andrew is undergoing the Early Neutral Evaluation or E&E process, which is a staple of the Minnesota family court system. Andrew is sitting in a sterile conference room, or perhaps a virtual Zoom room facing two evaluators. In the SENA, or Social Early Neutral Evaluation, the focus is entirely on the children. The evaluators listen to both sides for 2 hours, and then provide a non-binding recommendation on what they think a judge would do. This is the first high-pressure moment. Historical trends in 2026 show that many men, when faced with a negative SENA recommendation, feel an immediate sense of defeat. They assume the evaluator's word is law. It is not. However, the psychological impact is designed to make you fold. If you are Andrew, and the evaluator suggests a 60-40 custody split in favor of your spouse, the pressure to settle right then and there is immense. You are told that if you go to trial, you will spend another $50,000 in legal fees only to likely get the same result. This is the settlement trap. In 2026, Midwestern mediation often employs a tactic known as shuttle diplomacy. You and your attorney sit in one room, and your spouse and their attorney sit in another. The mediator moves between the two like a high-stakes negotiator. This is a battle of attrition. Case studies from recent years indicate that mediations in states like Iowa and Missouri often last 8 to 10 hours. As the clock ticks past 6 p.m., a phenomenon known as decision fatigue sets in. Your blood sugar is low, you are exhausted from the emotional toll, and you just want the nightmare to end. This is exactly when the most lopsided deals are presented. The mediator might come into your room and say, "Look, Andrew, she's willing to drop the lifetime maintenance demand if you just give up the equity in the rental property." Feels like a win in the moment because the pain stops. But when you wake up the next morning, you realize you traded a permanent capital asset for a temporary relief of a monthly obligation that might have been terminable anyway. To survive this, you must understand the difference between a mediator who is a neutral facilitator and one who is a closer. A closer uses fear as a primary tool. They will emphasize the risks of a trial, the unpredictability of the judge, and the potential for a total loss. They will remind you that in the Midwest, judges have broad discretion. While they aren't lying, judges do have discretion. The closer uses that uncertainty to push you toward a conservative, middle-of-the-road settlement that often favors the status quo. Historical trends suggest that the status quo in 2026 still leans toward the primary caregiver, meaning if you want to break that mold, you have to be the one willing to walk away from the mediation table. The alternative to a failed mediation is the pre-trial conference. This is where the shadow of the black robe becomes visible. In many Midwestern jurisdictions, a pre-trial conference involves the attorneys meeting with the judge in chambers, without the clients present. The judge reviews the pre-trial memos, detailed documents outlining each side's position on every issue from the lawnmower to the 401k. The judge then gives a judicial recommendation. They might say, "Based on what I see here, if this goes to trial, I'm likely to award 50-50 custody, but I'm also likely to grant the maintenance request." This is the most critical information you will receive in your entire divorce. In 2026, most experienced family law attorneys in the Midwest will tell you that the judge's pretrial leanings are about 80% accurate to the final potential outcomes. If the judge signals an unfavorable view of your position in pretrial, the risk of going to trial increases exponentially. However, there is a strategic layer here that many men miss. Some attorneys use the pretrial conference to test the waters. If your attorney is aggressive and well-prepared, they can use the pretrial memo to frame the narrative before the judge ever hears a word of testimony. If the judge in a Kansas City or St. Louis courtroom sees a clear, data-driven argument for why your business valuation is lower than your spouse claims, or why your parenting plan is more stable, that initial judicial lien can shift the leverage in your favor for one last round of settlement talks. Let's look at the financial stakes of 2026 Midwestern litigation. The cost of a full-blown divorce trial in a major metropolitan area like Chicago or Indianapolis has skyrocketed. You are not just paying for your attorney's time. You are paying for expert witnesses, court reporters, and the opportunity cost of being away from your work. A 3-day trial can easily cost a man $30,000 to $70,000 in additional fees. This is the financial gun that the system holds to your head during mediation. The question you have to answer is the asset I am fighting for worth the cost of the fight? If you are fighting over a $20,000 car, and the trial costs $30,000, the math is simple. But if you are fighting for your relationship with your children or $1 million pension, the math changes. The 2026 Midwest also sees an increase in the use of parenting coordinators, or PCs, when mediation fails to resolve custody. A PC is like a private judge for your parenting plan. They have the power to make binding decisions on the fly about holiday schedules, extracurriculars, and even daily pickup times. While this can reduce the need for constant court dates, it also means you are ceding even more control to a third party. Historical trends show that men who enter mediation without a clear, non-negotiable bottom line often end up with a PC who defaults to whatever the mother wants to avoid conflict. You must enter the mediation room in 2026 with two things: a precise financial spreadsheet and a willingness to say no. The system counts on your desire for peace. In the heartland, we are taught to be polite, to compromise, and to be the bigger person. In a divorce mediation, being the bigger person can result in you living in a studio apartment, while your ex-spouse stays in the 5-bedroom home on your dime. You must be prepared to sit in that room for 10 hours and walk out with nothing if the deal isn't fair. The moment the other side realizes you are not afraid of the courtroom, the nature of the negotiation changes. We have deconstructed the pressure cooker of mediation and the shadow of the pretrial conference. You now know how the system tries to break your will before you ever see a judge. But what happens if you don't fold? What if the mediation fails, the pretrial recommendations are unacceptable, and you find yourself standing in front of a judge for a final trial? In the next part of this masterclass, we are entering the courtroom. We are going to discuss the rules of evidence, the reality of witness testimony, and the high-stakes art of cross-examination in a Midwestern divorce trial. You will learn how to handle the pressure of the stand and what the judge is really looking for when you are speaking. The time for talking is over. The time for testimony has arrived. The trial is the final filter, and it is where the most permanent decisions of your life will be made. The moment you step through the heavy wooden doors of a Midwestern courtroom in 2026, the polite veneer of mediation vanishes. You are no longer in a negotiation. You are in an adversarial proceeding where the rules of evidence act as the primary filter for your reality. In a bench trial, which is the standard for divorce in states like Ohio, Indiana, and Michigan, there is no jury. Your entire future, your relationship with your children, and the distribution of your life's work rest in the hands of a single individual, the judge. To survive a trial in the heartland, you must understand that the court does not operate on feelings or fairness in the way you might define them at home. It operates on admissible evidence and the credibility of the person providing it. Imagine if you are Stephen, a civil engineer living in Cincinnati, Ohio, in September 2026. Stephen's case has failed mediation because his spouse is demanding 60% of his premarital retirement account and sole legal custody. As the trial begins, Stephen's attorney explains the concept of the burden of proof. Since Stephen is the one claiming that a portion of the retirement account is separate property, the burden is on him to prove it with a preponderance of the evidence. This means Stephen must produce a clear chronological paper trail dating back 15 years. In the 2026 judicial environment, simply saying "I remember having that money" is equivalent to saying nothing at all. The judge in a Midwestern courtroom values the spreadsheet over the story every single time. The first hurdle in any 2026 trial is the rules of evidence, specifically the rule against hearsay. Many men enter the stand wanting to recount what their children told them, what their neighbors saw, or what a therapist hinted at. In almost every Midwestern jurisdiction, these statements are inadmissible unless they fall under a specific exception. If Stephen tries to testify that his daughter said she wants to live with him, the opposing counsel will immediately object on hearsay grounds. The judge will sustain that objection, and that piece of information will be legally erased from the record. This is why witness preparation is a step-by-step necessity. You cannot rely on the voices of others. You must be prepared to testify to what you personally observed, what you personally did, and what you personally earned. During direct examination, which is when your own attorney asks you questions, your goal is to be a reliable narrator. In the 2026 Midwest, judges are looking for stoicism and consistency. Historical trends show that men who become overly emotional, aggressive, or evasive on the stand are viewed with suspicion. You must answer questions clearly and concisely. If your attorney asks about your involvement in school activities, do not just say "I am involved." You must provide a granular, data-driven answer. "I have attended 85% of the parent-teacher conferences over the last 3 years, and I am the primary contact for the school's emergency alert system." This level of detail builds a fortress around your credibility. Then comes the most dangerous phase, cross-examination. This is when the opposing attorney's job is to dismantle your character and your claims. They will use leading questions designed to force you into a yes or no answer. They might say, "Mr. Stephen, isn't it true that you missed your son's baseball game on June 12th because you were working late?" They are not looking for your explanation, they are looking for the admission. In the 2026 legal climate, the strategy is to paint a picture of an absent or disinterested father. Your defense in this moment is the pause. You must take a breath before every answer. This gives your attorney a chance to object, and gives you a chance to strip the emotion from your response. Potential outcomes for men who lose their temper during cross-examination include a judicial finding that they lack the emotional regulation necessary for a shared parenting arrangement. Case studies from 2025 and 2026 highlight the increasing importance of the rebuttal witness. If your spouse testifies that you have a substance use issue, or that you have been financially irresponsible, you cannot just deny it. You must rebut it with third-party evidence. This might mean calling your employer to testify to your consistent performance, or bringing in bank records that show every dollar you spent during the separation. In the Midwest, where the judiciary often prizes a man's reputation for reliability, a successful rebuttal can shift the entire momentum of the trial in a single afternoon. The role of the expert witness in a 2026 trial cannot be overstated. If you are fighting over the valuation of a family business in Indianapolis or the impact of a move-away request in Des Moines, the judge will rely heavily on professional testimony. Forensic accountants and child psychologists are the heavy hitters of the courtroom. When these experts are on the stand, the trial becomes a battle of credentials and methodologies. Historical data suggests that judges in the heartland tend to favor experts who use conservative, widely accepted valuation models. If your expert uses a radical new theory to value your business, the judge may discount their testimony entirely. You must be prepared to sit quietly while these professionals dissect your life, your finances, and your parenting style in clinical, often cold terms. We must also discuss the sniff test. While the law is written in statutes, the application of the law in the Midwest is often guided by a judge's internal sense of who is being more reasonable. In 2026, if you are fighting over every small household item, the toaster, the lawn chairs, the holiday ornaments, you are failing the sniff test. Judges in the Midwest have a low tolerance for what they perceive as petty litigation. If you show a willingness to be flexible on the small things, the judge is historically more likely to believe you are being reasonable on the big things like the house and the kids. As the trial winds down, you reach the closing argument. This is where your attorney ties all the evidence together into a final narrative. In the 2026 Midwest, a successful closing argument is not a dramatic speech. It is a roadmap. It tells the judge exactly which statutes apply to the evidence presented and why your proposed final decree is the only logical outcome. The judge will then take the case under advisement. Unlike what you see on television, you rarely get a decision the same day. In high-conflict cases in 2026, you may wait weeks or even months for the judge to issue a written opinion. This period of judicial limbo is often the most stressful part of the entire process. You have now survived the initial filing, the financial discovery, the custody evaluations, the digital forensics, the mediation traps, and the final trial. You have stood on the stand and defended your life. But the judge's signature on that final decree is not the end of the story. It is the beginning of a new legal reality. In the next part of this masterclass, we are going to dive into the aftermath, the final decree, and the reality of post-decree life. We will talk about the mechanics of qualified domestic relations orders, the actual process of moving assets, and the high-stakes world of modifications. Just because the divorce is over doesn't mean the court is out of your life. You need to know how to manage your new legal obligations and what to do if your ex-spouse refuses to follow the order. The battle may be won, but the peace must be managed. The final signature from a judge in a Midwestern courtroom does not signify the end of your divorce. It marks the commencement of your post-decree legal existence. In the 2026 legal climate, the judgment of dissolution is a living document that requires active management, and the failure to execute the specific terms of that document is where many men find themselves back in court within 6 months. You must understand that the court is not a concierge service. It will not call your mortgage company to remove your name from the loan, and it will not notify your human resources department to update your life insurance beneficiaries. Historically, the most dangerous period for a man's credit and financial stability is the 180 days following the entry of the final decree. Imagine if you are Derek, a 38-year-old pharmaceutical representative living in a suburb of Milwaukee, Wisconsin, in October 2026. Derek walked out of the courthouse with his final decree, believing the 50-50 split of the house equity was a settled matter. However, the decree stated that his ex-spouse had 90 days to refinance the home into her own name to remove Derek from the liability. In the 2026 real estate market, interest rates have made refinancing difficult. If Derek's ex-spouse cannot qualify for a loan on her own, Derek remains legally tied to that debt. If she misses a payment, it is Derek's credit score that takes the hit. Potential outcomes in this scenario often require Derek to file a motion to compel sale, a process that can take months and thousands of dollars in additional legal fees. Step by step, you must ensure that your decree includes a drop-dead date for refinancing and a specific provision that the house must be listed for sale immediately if that date is missed. Asset transfer logistics in the Midwest are heavily reliant on the execution of specific documents like the quitclaim deed for real estate and the qualified domestic relations order, or QDRO, for retirement accounts. In 2026, the backlog for QDRO processing at major financial institutions in cities like Chicago and Detroit can stretch for half a year. During this window, you are in a state of financial limbo. If the market shifts significantly, the value of the portion you are keeping or transferring may change. Historical trends indicate that men who fail to follow up with their QDRO attorney often find that their retirement accounts remain frozen or incorrectly titled long after the divorce is final. You must be proactive in confirming that the plan administrator has received and approved the order. The parenting plan is another area where the theory of the decree meets the friction of 2026 reality. Many Midwestern judges now mandate the use of co-parenting communication applications such as Our Family Wizard or Talking Parents. These platforms serve as a digital ledger of every interaction. If your decree requires all communication to happen via the app, and you continue to send text messages or make phone calls, you are technically in violation of a court order. Case studies from 2025 show that men who deviate from the prescribed communication methods often find those text messages used against them in future contempt hearings. The court views the app as a way to reduce conflict and create a clear evidentiary trail. If your ex-spouse is refusing to follow the parenting schedule, perhaps by being consistently 30 minutes late to the exchange at the local library or gas station, you must document this precisely within the app. Let's look at the case of Jason in Kansas City, Missouri. Jason has a 50-50 parenting split, but his ex-spouse began withholding the children for midweek visits, citing the children's school projects or minor illnesses. In the Midwest, the legal remedy for this is a motion for family access or a motion for contempt. In 2026, judges have a range of sanctions available, including awarding make-up parenting time, ordering the payment of your attorney fees, or even putting a bond on the other parent to ensure future compliance. However, you cannot take the law into your own hands. If you are denied time, you cannot simply withhold child support in retaliation. Historical trends show that judges view the withholding of support as a separate and equally serious violation, often leading to a situation where both parents are found in contempt. Modification of support is the most common post-decree battleground in the 2026 Midwest. The law recognizes that life is not static. In states like Illinois and Ohio, you can typically file for a modification of child support or maintenance if there has been a substantial change in circumstances. This usually means a 20% or greater change in income. Imagine if the manufacturing plant you manage in Grand Rapids, Michigan, undergoes a massive restructuring in late 2026, and your salary is reduced by 30%. You do not automatically get to pay less. You must file a petition to modify immediately. Historical data suggests that support obligations can only be modified retroactively to the date of filing. If you wait 6 months to tell the court you lost your job, you will still owe the higher amount for those 6 months, regardless of your inability to pay. There is also the 2026 reality of the emancipating child. In the Midwest, child support does not always end automatically when a child turns 18. In states like Indiana, child support can continue until 19, and in Illinois, you may be on the hook for non-minor educational expenses, commonly known as college contribution. This is a unique feature of Midwestern law where the court can order you to pay for a portion of tuition, room, and board at a university like Purdue or the University of Iowa. Step by step, you must audit your decree to see when these obligations trigger and what the cap is on those costs. If you fail to plan for the college contribution phase, you could face a massive financial shock just as you are beginning to recover from the initial divorce costs. Taxes post-divorce in 2026 and 2027 require a complete shift in strategy. You are now filing as single or head of household. The dependency exemption, who gets to claim the children on their taxes, is often rotated annually in the Midwest. However, federal tax law and state court orders sometimes conflict. If your decree says you get to claim the child in even-numbered years, but the IRS rules say the custodial parent gets the credit, you must have a signed IRS Form 8332 from your ex-spouse. Without this form, the IRS will default to the parent with more overnights, potentially leading to an audit and the loss of the credit. The 2026 Midwestern legal system is built on the principle of finality, but it leaves the door open for those who can prove a material change in circumstances. Whether it is a relocation of a parent more than 25 or 50 miles away, a significant increase in the other parent's income, or a change in the child's needs, the post-decree phase is a constant monitoring of the legal landscape. You must remain as organized and data-driven as you were during the trial. We have now navigated the entire arc of the Midwestern divorce, from the initial shock of the filing to the complex management of a post-decree life. You have the tools to protect your assets, your reputation, and your relationship with your children. But there is one final piece of the puzzle that is rarely discussed in the legal textbooks: Yet it is the factor that determines whether you merely survive your divorce or actually thrive after it. In the final part of this masterclass, we are moving beyond the statutes and the courtrooms. We are going to talk about the long-term blueprint for rebuilding. We will discuss the 2026 strategies for asset recovery, the psychological transition into a new identity, and the specific pitfalls that lead men back into high-conflict relationships. The legal battle is the foundation, but the life you build on top of it is the true goal. We are closing the loop on the Heartland Gauntlet and showing you the path to the other side. The transition from the finality of a courtroom to the vacuum of a new life is the phase where most Midwestern men either cement their recovery or begin a slow slide into long-term stagnation. In the 2026 economic reality, the goal is no longer just about the division of what was, it is about the strategic assembly of what will be. You have emerged from the Heartland Gauntlet with a decree that defines your obligations, but that document is merely the floor, not the ceiling. Historical trends show that men who successfully navigate the first 24 months post-divorce are those who treat their personal life with the same rigorous logistical oversight they applied to their legal case. You are now the chief executive officer of a new, leaner entity, and the 2026 landscape requires a specialized blueprint for recovery. Let us look at the psychological restructuring of the provider identity. In the Midwest, the cultural weight of being a husband and a father is often the primary pillar of a man's self-worth. When the husband title is stripped away, many men experience a crisis of purpose that can lead to poor decision-making in both their professional and personal lives. Imagine if you are Marcus, a 50-year-old plant manager in Flint, Michigan in 2026. Marcus spent 25 years identifying as the head of a specific household. After the divorce, he finds himself in a modern apartment, his 401k halved, and his social calendar empty. The potential outcome for Marcus, if he does not pivot, is a phenomenon known as the isolation spiral. In the Midwest, social circles are often shared and church-centric or community-based. Marcus may find that his old friends feel a sense of divided loyalty, leading to a loss of his traditional support system. The step-by-step fix for this is the intentional construction of a new social infrastructure that is independent of the previous marriage. This is not about forgetting the past. It is about protecting the future from the shadow of the old decree. Financially, the 2026 recovery phase is a race against time and inflation. If you are a man in your 40s or 50s, you have likely lost half of your marital assets and are currently paying out a significant portion of your net income in support. Historical trends in 2026 indicate that the most successful financial recoveries for men in this region involve aggressive use of catch-up contributions and tax-advantaged accounts. If you are over 50, the IRS allows for higher contribution limits to your 401k and IRA. You must maximize these. Additionally, you should explore the 2026 trend of the side LLC. Many Midwestern men are utilizing their professional skills, whether in engineering, logistics, or trades, to create secondary income streams that are structured to be separate from their primary salary. However, you must be cautious. As we discussed in the maintenance section, a significant increase in income can sometimes trigger a modification request from an ex-spouse. Case studies suggest that consulting with a tax professional to understand how to reinvest business earnings back into the company, rather than taking them as personal income, is a vital defensive maneuver in the post-decree years. We also have to address the 2026 reality of estate planning for the divorced man. This is a massive legal blind spot. If your final decree was entered in Ohio or Indiana, you might assume your ex-spouse is automatically removed from your will or your life insurance. This is a dangerous assumption. While some states have statutes that automatically revoke a former spouse's status as a beneficiary upon divorce, these laws are full of loopholes, particularly regarding employer-sponsored plans governed by federal ERISA law. Step by step, you must execute a new will, a new power of attorney, and a new healthcare proxy. Imagine if you were to have a medical emergency in 2027. Without updated documents, the person making decisions about your life and your assets could still be your ex-spouse. You must also update the transfer on death or TOD designations on all your bank accounts, and the deed to any real estate you retained. In the 2026 dating and social landscape, Midwestern men are facing a high-risk environment. The impulse to find a new partner to fill the void of the previous marriage is powerful, but from a legal perspective, it is a minefield. Many maintenance orders in the Midwest include a cohabitation clause. This means that if you move in with a new partner, or if your ex-spouse moves in with someone, the maintenance obligation might be terminable. However, proving cohabitation in 2026 is complex. It often requires evidence of shared finances, shared chores, and a permanent residency. If you are the one paying maintenance, you may be tempted to hire a private investigator to prove your ex-spouse is cohabitating. Historical data shows that while this can be successful, the cost of the investigation often exceeds the short-term savings on maintenance. Conversely, if you are the one looking to move forward with a new relationship, you must be aware of how that partnership looks to the court if you are ever back in a modification hearing. The concept of the prenuptial agreement has become a standard requirement for the 2026 divorced man considering remarriage. Having been through the Heartland gauntlet once, the historical trend shows that men are no longer viewing prenups as a sign of distrust, but as a mandatory insurance policy. In the Midwest, where courts have broad equitable discretion, a well-drafted prenup is the only way to ensure that your premarital assets, those you fought so hard to keep in your first divorce, remain protected in a second. You must be transparent with any new partner about this. The 2026 conversation is no longer about if you will have a prenup, but about how it will be structured to protect both parties while acknowledging the reality of your existing support obligations. Co-parenting in the long term requires a shift from an emotional relationship to a business relationship. The most successful post-decree outcomes for men in the Midwest occur when they stop treating their ex-spouse as a person they used to love and start treating them as a difficult business partner with whom they share a single, high-stakes project: the children. This means keeping all communication professional, brief, and documented. If you are in a high-conflict situation, the 2026 move is to insist on parallel parenting rather than co-parenting. In parallel parenting, each parent makes the day-to-day decisions for the children during their time without needing to consult the other, provided they adhere to the major decisions outlined in the decree regarding health and education. This reduces the friction points and allows the children to transition between two different, but stable environments without being caught in the crossfire of constant negotiation. As you look toward the horizon, the final piece of the 2026 masterclass is the legacy phase. You have protected your assets, you have secured your time with your children, and you have reorganized your finances. Now you must focus on the long-term emotional stability of your children. Historical trends indicate that children in the Midwest who see their fathers successfully rebuild a stable, productive life are far more likely to have positive outcomes themselves. Your resilience is their roadmap. The court may have divided your house and your bank accounts, but it could not divide your character or your capacity to lead. The Heartland Gauntlet is a grueling process designed to test every facet of a man's resolve. From the first 48 hours of a surprise filing to the complex calculations of maintenance and the high-pressure environment of a 2026 trial, you have been given the deep-dive intelligence needed to navigate this system. You understand that in the Midwest, the law is a machine, and your job is to provide the data that ensures the machine works for you, not against you. The peace you find on the other side is not a gift from the court. It is something you have engineered through preparation, stoicism, and a relentless focus on the future. This concludes the 10-part masterclass on divorce for men in the U.S. Midwest. But while this series has provided the map, the actual journey is unique to every man. The legal landscape of 2026 continues to evolve, with new statutes and judicial interpretations appearing every session. Staying informed is your permanent responsibility. The next challenge is not a legal one, but a personal one. How will you use this hard-won freedom? The loop is closed on your old life, and the first chapter of your new one is currently being written by your actions today. The most important hearing of your life is the one you conduct with yourself every morning. Now that you have the knowledge, the only question left is what you will build next.